Good afternoon, everyone. It's good to be here with you all again to talk about GHS and the latest and greatest from OSHA. We want to spend the next hour, hour and a half talking about what has happened to GHS since it's been promulgated. As you all know, I'm sure, in March of 2012, OSHA promulgated a very significantly different hazard communication standard to be consistent with the global harmonization system that has been adopted worldwide, essentially. And since that time, there have been numerous what we call rollout issues, where OSHA has been sort of real-time interpreting what their regulatory text means. We have gained a lot of guidance from the agency over the last couple of years as to what the text that was promulgated in March 2012 means through interpretation letters, enforcement memoranda that the agency has issued. And what we're trying to do here is inform you all as to what OSHA means by the various provisions of the new revised HCS. So without further ado, why don't we begin? One of the most important things, my colleague Dan Deacon is going to begin here by talking about the agenda we've set up for today and doing some background for those of you who are not as spending every waking moment at your office trying to interpret GHS. He'll give you some background, and then we'll talk about specific enforcement issues, implementation issues, and other sort of details about the rollout. But let me just begin before I turn it over to Dan by reminding everyone, and Dan's going to talk further about this when he talks about compliance deadlines, that we are about to be upon the last deadline, at least regulatory text deadline, that exists for HazCom. As you all know, probably, OSHA set a series of staggering deadlines when it promulgated the standard to give companies, employers, chemical manufacturers and importers and distributors time to come into compliance with the new standard. We have now, all of those deadlines except for the last one has essentially come and gone, and we are now about to face the June 1st, 2016 deadline, and Dan's going to tell you about what that means. But that is essentially it. Once this June 1st comes, we will be in, everyone should be in full compliance with the new hazard communication standard as it was promulgated in March 2012. Now, we also will talk to you about some deferrals that the agency has given in order for companies to sort of catch up and come up to speed under various circumstances. But there are thresholds that have to be met to benefit from those deferrals generally, and we'll talk about those as well. So with that, Dan is going to begin.
All right, great. Thanks, Kate, for the introduction. Just a quick little introduction from myself. My name's Dan Deacon, and I'm an associate here at Conn Maciel Carey. I've been here for quite a while now, about 8-9 months, relatively new associate, I guess. But again, today we're going to be talking to you about OSHA's new GHS HazCom standard and some of the rollout issues. The HazCom's always been an important topic in OSHA circles, and it's very important in 2016. As Kate mentioned, the final rollout deadline's quickly approaching, June 1st. 2016. That's less than a month away. And over the past year, HazCom was one of the most cited standards by OSHA in its book. So we're going to talk about a lot of things, especially some of the recent guidance that has come out, the compliance directive that was issued last year in July 2015, and the recent hazard classification guidance that came out less than 3 months ago in February 2016. So let's move on to the agenda here. We can skip over our bios here and do the introductions. So just a quick background of again, what we're going to be speaking about today. First, I'm going to address the background of the GHS and the revised HazCom standard, the 2012 standard. We're going to talk about the requirements of the new standard, and then some of the rollout issues and the June 1st compliance deadline, and the enforcement issues with the new standard, and some things to look out for in 2016 and going forward. So let me just first address the original HazCom standard. OSHA first published the HazCom standard in 1983. It was pretty limited, however. It was only applied to chemical manufacturers and importers. It didn't apply broadly to employers that generally had chemicals in the workplace. So OSHA revised the standard in the mid-1980s by proposing, of course, a broader standard that covered all workplaces that had chemicals where workers were exposed to hazards under normal conditions of use. This standard was litigated in the mid-80s and resulted in a revision in around 1989, I believe. And since then, we've pretty much had the same standard with the exception of some minor revisions in 1994. And of course, there's been a number of interpretations and guidance documents issued by OSHA based on those regulations that were unclear. So on the slide here, you see the 5-element program. That was it's basically the bread and butter of the HazCom standard under both the original standard and the current standard. The original standard was quite simple with respect to its structure and interpretation. The 5-element program that you see here, it consisted of 1, the determination of chemical hazards in the workplace. That's how you assess, evaluate, and identify hazardous chemicals. 2, the development of a written HazCom program. That's the same thing today under the revised standard. The labeling of hazardous chemicals. The development of material safety data sheets, now dubbed safety data sheets, simply removing the material part. And training of workers on hazards and precautions. So the key point here between the original standard and the revised 2012 standard is that the old standard was performance-based. There was a lot of discretion left to the chemical manufacturer to assess, evaluate, and describe those hazards, and there wasn't a lot of information that was mandated on the labels and the Sdss and the format. Go on to the next slide here. And we'll talk about the UN's globally harmonized system of classification and labeling of chemicals. So in a nutshell, the language on this slide describes the purpose of what GHS is. It's to develop a systematic approach for employers to evaluate workplace hazards and provide employees consistent information regarding chemical hazards that they may encounter in their workplaces. So this was formally adopted in 2002 by the UN. And if you look at the GHS, a key point here, it isn't a model standard. It's essentially a set of concepts and provisions that the GHS Coordinating Committee drafted for countries to adopt and incorporate into their existing regulatory structures. So again, it's a set of building blocks for countries to use. One of the things to understand about GHS also is that it's a living document. So as science and technology changes, the GHS is going to continue to change. When the 2012 HazCom standard was adopted by OSHA, they were looking at GHS Rev 3, and we've had 3 subsequent revisions since then. We're now on GHS Rev 6. OSHA is likely going to continue to adopt the GHS changes as they come into order just to be consistent with the GHS. So how they're going to modify the HazCom standard itself, it's yet to be determined, but they can go through notice and comment rulemaking, or they can even issue a direct final rule, which is a tool they have, but they rarely rely on. So we'll see how that plays out in the future. All right, and then comes the 2012 revised HazCom standard. And the purpose of the revised standard is mainly to enable a better understanding of the hazards that employees are exposed to in the workplace. And that's the overreaching goal in a nutshell. So employees are going to have a better understanding of what's in the workplace and how to protect themselves and others from those hazards. So what do we get with the 2012 revised standard? What's different from the old standard? Well, some things are different, some things are the same. We get the same 5-element program that was in the 1983 standard. The big difference, as we discussed a couple slides ago, was the shifting from a performance standard, which is very discretionary, to a highly detailed specification standard. And these specifications, the specific approach here relates mainly to how you're going to assess, evaluate, and determine what a hazard is, or whether a chemical poses a hazard. That's the hazard classification process. It's basically what you did under the old standard, but there's new requirements and mandatory guidance, or not mandatory, but guidance out there to help employers in this process, and that's changed quite a bit, which we'll discuss a little later in the presentation. It also mandates specific formats for SDSs and labels. The content and language that's going to be included on the label in SDS now is much different, and there's a very strict structure that's laid out in the appendices to the 2012 standard. And finally, last point here on the slide, you see a comment from Dr. Michaels and his characterization of the law. So basically, with the adoption of the 2012 standard, Dr. Michaels dubbed this as a right to understand law, meaning not only are employers or our employees going to know about the potential hazards, but they're also going to be able to better understand what the warnings mean, what to do if they're exposed, and of course how to protect themselves and others. So as I've kind of been going through this, I've mentioned there's been some major changes. Of course, you all know this by this point. We're going to get into the nuts and bolts of those changes now, specifically as they relate to the hazard classification process, labeling, safety data sheets, and training. So that's what we're going to get into now. But before that, I want to touch really quick on the organization of the new standard. And here's really where we can get into the meat of the webinar. And the specification approach, this is basically coming from the appendices to the new standard. The content, the regulatory language itself isn't all that different from the old standard. It's nearly identical. The big difference is these mandatory appendices that you see, appendixes A through F. Appendix A and B, the health hazard criteria and physical hazard criteria, those are going to be what you use in your hazard classification process. Appendix C lists the mandatory requirements for labeling. Appendix D, the 16 points that you need to touch on safety data sheets. And Appendix E has the definition of trade secrets. Appendix F, the guidance for carcinogenicity classification. So first, let's start with the hazard classification and categorization here. One of the main purposes of the HazCom standard is to ensure that the hazards of all chemicals produced or imported are classified, and that the information of those chemicals is transmitted to employers and workers. The key point here, though, is the standard only covers hazardous chemicals. So there needs to be some kind of determination whether the substance itself is a hazardous chemical under the standard, and that's what we refer to as the classification process. The definition of a chemical, it's extremely broad under the standard. The definition is any substance or mixture of substances. So virtually any product can be a chemical. So the key word here is hazardous, right? Employers need to classify both the health and physical hazards of a chemical. In doing so, you're going to look to appendixes A and B. They're going to tell you how to assess and classify these health and physical hazards. Furthermore, OSHA just recently issued that 432-page document that I referenced earlier to help guide manufacturers, importers, and distributors through this classification process. And we're going to dive into the nuts and bolts of that a little later. We have a slide specifically dedicated to that guidance and the new weight of evidence rule. But right, there's going to be two steps here. So first is the need to identify the hazard class, which is essentially the nature of the hazard. What type of hazard are we talking about? Is it acute toxicity, flammability, and also the hazard category. That's going to be step two, identifying the hazard category, and that's basically the degree of severity associated with a chemical. So for example, flammability has 4 levels, same thing with toxicity. And the appendices explain all this. Again, appendices A and B. And the final point on this slide is that the new HazCom standard, the revised HazCom standard, eliminates the previous one study rule. So under the previous standard, if there was one study that identified a hazard with a chemical, that was sufficient to determine if it was hazardous. That was it. You had a lot of flexibility about how you described that hazard, and it was very discretionary. Now it's based on the weight of evidence analysis using expert judgment. So when the rule was finalized, chemical manufacturers raised some complaints about this because there was virtually no guidance about what this weight of evidence analysis really meant. And currently now there's draft guidance that's on OSHA's website. The comment period closed about a little over a week ago. I think it was May 2nd, 2016. So we'll see if there's any changes to that. However, it's about a 30-page document. And if you're involved in the hazard classification process, you should certainly get on OSHA's website and take a look at that, and we'll go over that shortly. But overall, from this slide, what you need to know is it's essentially a holistic approach to hazard classification. You're going to look at all the evidence that's out there and come to a determination based on that analysis. Now I'll move on to safety data sheets. The big difference here between what we all previously knew as material safety data sheets and the new safety data sheets is that you need to follow a prescribed format in creating the new SDSs. So what is the purpose of these SDSs for those of you out there that are new to HazCom? It's basically intended to provide a comprehensive overview or the information about a substance or mixture in the workplace. And it's supposed to be maintained in the workplace itself. So the burden is going to fall on the chemical manufacturer to comply with this, but as a downstream employer, you're also going to have some obligations. You're going to need to make sure you have a version that complies with the new SDSs and make some effort to clear out your MSDSs and get those new SDSs in, especially with these final rollout deadlines approaching. However, there are some deferrals, which we'll also talk about later. So not much of the substance actually has changed. The content itself from the safety data sheets, it's just the format itself to make it a little more clear. But it's more or less the same. So for those of you out there that perhaps used a format that was from the ANSI Z40.1 standard, it's basically the exact same. So entities that had already switched over or followed the ANSI standard, they're already in compliance with the new SDS requirements. One of the other points on here is you also need to include on the SDSs the ACGIH TLVs, the threshold limit values, and the IARC and NTP carcinogenicity, carcinogenicity information on the SDS. The ACGIH, I believe, is the American Conference of Governmental Industrial Hygienists. IARC is the International Agency for Research on Cancer, and NTP is the National Toxicology Program. So interesting to note here that these levels are often more stringent than OSHA's permissible exposure limits, the PELs. And the idea of posting on your SDS a TLV value, which is lower than the PEL, has already caused some interesting issues for some industries where they're receiving a citation under a general duty clause for violating one of these standards. So as you all know out there, the general duty clause allows OSHA to enforce recognized hazards. Here, there is a recognition, which OSHA basically says is recognized by the employer there on the SDS. So it's an example of enforcement at a level below the threshold that OSHA sets, but above the threshold of some non-mandatory standard published by an independent entity. And finally, the last point for safety data sheets here, if a chemical manufacturer gathers new health information, for example, that's going to be from a new study that warrants a change on their SDS, they have 3 months from the date of receipt of that new information to update the SDS. After that 3-month point, the next shipment of that chemical, it's going to need to have the new SDS sent along with it. And here, I won't talk much about this slide, but this is the 16-part mandatory format. If you all want to just read through it really quick, that's going to detail everything that you need in the safety data sheet. And if you look at sections 12 through 15, it notes that OSHA does not enforce the content. So for example, section 12, ecological information, that's going to be regulated by EPA. Section 14, transport information, that's going to be regulated by the Department of Transportation. All right, now we'll go on to talking about some of the changes with labeling. The new requirements, there's new requirements, and this is something that's quite new to the revised HazCom standard. A lot of entities were already following what's now required, but here it is. There's 6 requirements or 6 items that must be on the labels. So first, as you see on the slide here, a common signal word. That's going to be either danger or warning, something to that effect. You're going to need a word that indicates the relative seriousness of the hazard associated with the chemical. 2, you're going to need a pictogram. I think there's 9 different pictograms, all of which are in a red triangular border. You can see the pictures on the slide there. It's going to need a picture within that red triangular border. 3rd, a hazard statement. That's a brief description of the nature of the hazard. For instance, fatal if swallowed. That's a hazard statement associated with Category 1 and 2 acutely toxic chemicals. I think Category 3 and 4, that needs a statement harmful if swallowed. 4th there, you're going to need a precautionary statement on the label. That's the most lengthy word-wise of all the new requirements. The appendices demonstrate that some of the language must be in bold on the label. That's bold in the appendices. That's mandated language that needs to be on the label itself. The language that's not in bold is basically a directive to chemical manufacturers to fill in the blank. And the italicized language is in there too, but it's not required, and it can't be on the label itself. It just provides additional information for the manufacturer to use in creating that label. 5th, you're going to need a product identifier. That's pretty simple. That's basically the name of the substance, what it is. And finally, a supplier identifier. That's the name, address, telephone number of the supplier. And all of that information regarding the labeling requirements, that's going to be found in Appendix C of the revised HazCom standard. Finally, one of the final point down there regarding alternative workplace labeling. Employers are permitted to use an alternative labeling system in the workplace so long as it complies with all the other requirements of the revised standard. And that's one of the final rollout deadlines here. Everything needs to be in order by June 1st, 2016. And this, the alternative labeling standard is subsection F7 of the revised HazCom standard if you want to take a look at that specifically. But this only applies to containers that are going to be used in the workplace and they're not going to be shipped. Okay, so this concept was in the old standard as well. It's not necessarily new, but the idea is that the label conveys something about the chemical to the workers, and they have an immediate understanding of the health and safety hazards associated with that chemical. So, although the in-house labeling systems are permitted, you're going to need to make sure that you have the Sdss in place in the workplace. You're going to need to make sure that employees are trained so that they're aware of all the information required to be conveyed under the HazCom standard, and it otherwise needs to be consistent with the HazCom standard. And OSHA says that in any enforcement action, the employer is going to bear the burden of demonstrating the effectiveness of this alternative workplace labeling program and demonstrate employee awareness of the HazCom standard, the requirements of under the HazCom standard. All right. Briefly here, before we get into some of the compliance deadlines, I want to talk quickly about some of the future changes to HazCom and what might come of that. It's important to keep in mind, again, as I said, that this is a living document. It's always changing based on science and technology. We're currently on GHS Rev 6, issued in 2015. But some important things to keep in mind as this is changing. So where there's a conflict between the Purple Book and the revised HazCom standard, reliance on the Purple Book alone is going to be considered a violation. Sometimes the GHS uses should language for labels, but the HazCom standard itself uses mandatory language. As for the changes that have come forward in the GHS Rev 6, there isn't a whole lot of substantive changes. There was one new hazard class that they identified, pyroporic gases, but that's already covered in OSHA's 2012 standard, so it's likely that we won't be seeing any changes based on this GHS Rev 6 that was issued last year. All right, so we're going to touch on the compliance deadlines here. We're in the final year of the rollout. Of course, as I said, it's less than a month away. but let me just touch on the history really quick. So by December 1st, 2013, employees had to be trained on new label elements and Sdss formats. June 1st, you had to comply with all modified provisions of the revised standard, except the alternative workplace labeling that we just went over. And then by December 1st, 2015, distributors were allowed to continue shipping products with old HazCom labels. And after that date, they were supposed to ship with the new HazCom labels. However, there's been some deferrals, which we'll touch on in a slide or two. And of course, June 1st, 2016, the most important one going forward here now, employers, manufacturers, and distributors, they're going to need to update their alternative workplace labeling systems to ensure they comply with the new standard, have a written HazCom program in place in the workplace, and 3, ensure that employees are trained on newly identified physical or health hazards. So these are likely going to be 3 issues that OSHA focuses on in the later part of 2016 here. They're going to probably increase their enforcement efforts, and we all know OSHA likes to regulate by enforcement. So we'll touch really quick on some of these specifically. First, the written hazard communication program. This was required under the old standard as well, so it may be a matter of just updating the written program itself. But the requirements of the written program are going to be in subsections F, G, and H, and it includes the following. 1, a description of the container labeling process. 2, a list of all the hazardous chemicals known to be present in the workplace. 3, a description of Sdss and the process for preparing or obtaining Sdss, the process to monitor them, procedure to follow when they're not received, and when they need to be updated. The method by which employers are informed of the chemical hazards, and lastly, the method by which employees can obtain the written program and an explanation of that training process. Speaking of training, we'll touch on some of the HazCom training issues here. First, HazCom training must be provided at no cost to employees, and employees are required to be paid for their time spent training. You need to provide training in a language that employees understand. Training isn't satisfied solely by giving an Sdss to an employee. You're going to need to do something more here. You need to explain the hazards of the chemicals, how to access and use information from Sdss and labels, and really make sure that employees understand, right? This is dubbed the right to understand law by Dr. Michaels, so keep that in mind. The training may be done in a classroom, it can be done by video or CBT, but there has to be some kind of forum for employees to ask questions. And finally, chemical-specific training isn't required. You can do it by hazard-based training, for example, flammability, corrosives. So that's something to keep in mind going forward as well. You can really limit your training and do it by a category, if you will. So employers need to provide employees effective information and training on hazardous chemicals in their workplace, both at the time of their initial assignment when they're hired and whenever a new chemical is introduced into their workplace. So this is a continuous duty to keep that training updated, right? So in terms of what the training should actually include, that OSHA has a number of things that the training needs to include, and that's the requirements of the HazCom standard, 1. 2, any operations in the work area where hazardous chemicals are present. 3, the methods and observations that may be used to detect the presence or release of hazardous chemicals. 4, the physical health, simple asphyxiation, combustible dust, and pyroporic hazards in that work area. 5, the measures employees can take to protect themselves. And finally, details of the HazCom program developed by the employer. Oh, and one more thing about training, the way in which the information is conveyed, there's no specific, mandated manner in which you have to present this information. It's up to the trainer to determine how this information is actually conveyed. So there's a little discretion in that regard. But it's also a good idea, finally, for employers to review their HazCom program, their written HazCom program, and frequently just make sure that it's still working effectively. Evaluating the effectiveness of your program is always going to help you make improvements and make a safer work environment. So the enforcement deferrals, as I mentioned this earlier, this is something important that a lot of you should definitely take note of. So first, manufacturers and importers, they're supposed to comply with the labeling and SDS requirements by June 1st, 2015, and the compliance deadline for distributors to comply with those was December 1st, 2015. However, there is some leeway, of course, if they don't have the required information from upstream employers, or upstream suppliers, I'm sorry. How are they going to create these SDSs and labels if they don't have the information, right? So manufacturers and importers can defer compliance with the 2012 requirements if they cannot comply due to circumstances out of their control, and they exercise reasonable diligence and good faith in trying to comply with the revised standard. And they're going to need to provide documentation to show they made some effort to obtain that information from upstream employers, find hazard information from alternative sources, and classify the data themselves. And this is all taken from the compliance directive. The deferral period for SDSs, manufacturers and importers are going to need to create the SDSs within 3 months from the date receipt of the necessary HazCom data. I know it says 6 months on the slide there. That's because the compliance directive states that employers and manufacturers and importers, they're only going to be cited when they haven't developed a 2012 SDS within 6 months of receiving the necessary HazCom information. So you really have 6 months. It does seem a little odd, but that's their enforcement discretion coming into play. And labels, they must also be created within 6 months from the date the SDS is developed. As for distributors of chemical mixtures and substances, they can use the 1994 compliant labels until December 2015. However, the same reason that manufacturers and importers have a deferral, because they haven't received the necessary information, distributors also have a deferral. They can continue using the 1994 labels until December 1st, 2017. But again, similar to the manufacturers and importers, distributors are going to need to show reasonable diligence and a good faith effort to comply with obtaining that information. And they're going to need to show documentation and communications with the manufacturer or importer in their attempts to obtain that information. So as for the SDSs, after receipt of the 2012 HazCom compliant SDS from a manufacturer or importer, the distributor is going to need to provide that SDS to a downstream user with the first shipment or upon request. Employers generally must maintain the most recent MSDS or SDS provided by a manufacturer, importer, or distributor. The employer can maintain the MSDS for applicable chemicals and be compliant with the 2012 standard until they receive an SDS, an updated SDS, from the manufacturer, importer, or distributor. So there won't be any problems there. But once the SDS is provided, it needs to replace the MSDS. And once the 2012 label is received, employers need to maintain those 2012 compliant labels on their chemical containers or follow the alternative workplace labeling requirements that we discussed a few minutes ago. Finally, one last point here is what happens with the products that you have in your workplace that already have the 1994 labels on them now, the existing stockpile. So for the existing stockpile with 1994 labels already on them, manufacturers are allowed to use these until June 1st, 2017, and distributors can use them until December 1st, 2017. So you need to get rid of the 1994 labeled stockpile by then, or you're going to have to relabel the product.
And just a clarification, Dan. So what Dan was just talking about is the responsibility of chemical manufacturers. The issue of whether an employer who's not a manufacturer has to replace labels. OSHA has made very clear your responsibility as an employer with regard to SDSs. You don't have to replace, as Dan just said, the old MSDSs unless and until a new, the old MSDSs unless and until you receive a new SDS. However, the agency has been less clear about an employer's responsibility vis-a-vis a label, but they've been very clear about the deferral period that a chemical manufacturer has to replace a label on an existing chemical, and that is till 2017, June or December?
For the chemical manufacturer?
Right.
That is June.
June 2017.
Yeah, June 2017, and for distributors, December 1st, 2017.
It makes sense that the same rationale that OSHA has adopted for SDSs applies to labels for employers, non-manufacturing employers, but we haven't had any clear guidance on that yet.
Okay, perfect. So now we'll go on to talk about some of the more recent guidance that has come out since the 2012 standard was adopted. There's been a number of interpretations, letters of interpretation and guidance issued by OSHA in the past few years, and this slide's just a quick list of some of those that you should definitely be aware of. First is the compliance directive at the top there, the inspection procedures for the hazard communication standard, and that was published last year, July 2015. The second one there is the most recent one, published in February 2016, and that's guidance for manufacturers, importers, and employers on the hazard classification process. And of course, we already touched on the weight of evidence. The weight of evidence guidance that is in draft form, and the comment period just closed about a week ago. And again, a lot of interpretation letters, which we're going to address later in the presentation. Kate's going to talk to you about a lot of the recent interpretations concerning the revised HazCom standard. And of course, just something to keep in mind is the future revisions to the GHS and how that's going to change going forward. So this slide, just a brief introduction. Since the revised HazCom standard went into effect, there's been a number of thorny implementation issues, including some of the main ones here: hazard classification with respect to the weight of evidence analysis, labeling issues, manufacturing for export only, small packages, and the use of other agency or country hazard labels in addition to the 2012 HazCom labels, and of course safety data sheets. So now we'll get into some of the more specifics of these implementation issues for you and how OSHA has interpreted several of these HazCom standards in practice. So first we'll start with the hazard classification. That's the first step, right? So in February 2016, very recent, 3 months ago, OSHA issued guidance for the classification of chemicals. And the hazard classification process is the process of evaluating a range of available scientific evidence to determine if a chemical is hazardous and identifying the level of severity of the hazardous effect. So this guidance provides an extensive explanation, and it provides several appendices to help manufacturers, importers, or employers with the classification process. As you see on the slide here, that process is identifying the chemicals, identifying the relevant data regarding the hazards of a chemical, reviewing the relevant data to ascertain the hazards associated with that chemical. Fourth, determining whether the chemical will be classified as a hazard according to the definition of hazardous chemical under the standard, and determining the degree of that hazard where appropriate by comparing it with the data and the criteria for health and physical hazards that you find in Appendix A and B of the HazCom standard. So this guidance, it's 432 pages, not the most enjoyable read, I guess you could say. However, it does contain a host of information if you're involved in the hazard classification process that's very important. It has four main sections, I would say. The first one being the process of data collection. What kind of data are you going to be looking for in making this determination? Second, the process and information needed for data analysis. Third, how to record the rationale used to develop a product's classification of hazards. And fourth, it has guidance on the classification of those health and physical hazards. It simply provides employers a lot more detail, resources, and examples about how to properly classify chemicals. It has specific criteria for physical and health hazards of substances explained throughout, specific substances. So OSHA believes that this guidance is going to help evaluators classifying chemicals and ensure that they're generally reaching the same conclusions. this seems a little odd because it's a qualitative assessment, right? It's based on an expert's judgment, and it's inherently a little discretionary. But OSHA is pretty confident that this guidance is going to keep everyone coming to the same general conclusions in their hazard classification process. So what are we talking about here with regard to what you need to conduct the hazard classification? There's three primary resources required for the hazard classification process. First, you're going to need a complete, accurate, and the most up-to-date literature and data concerning the chemical in question that you're analyzing here. Second, the ability to properly understand and interpret the information retrieved. So this is based on the weight of evidence analysis, as opposed to that single study rule under the old standard that we addressed earlier. And of course, you're going to need someone that's competent enough to do this analysis. And finally, third is the specific criteria for each health and physical hazard class and category that's defined in the HazCom standard. So what's really helpful for those that are involved in the classification process is these appendices in the guidance. This is something that you're really going to take a look at. Some of the appendices simply define terms that are used in the booklet and in the standard itself, and others actually provide outside resources to assist in the classification process and a list of chemicals that are already considered toxic or hazardous by OSHA as well. So three in particular are key and should be carefully reviewed by those who are involved in the classification process. Appendix B contains a list of sources to assist in the classification process. It's quite lengthy. Appendix C contains a list of chemicals for which OSHA adopted permissible exposure limits. It's a helpful starting point for identifying chemicals that are hazardous. And Appendix D contains a list of all of OSHA's designated carcinogens. So it's important to keep in mind as you're going through this that the HazCom standard doesn't have a floor like a list of chemicals predetermined to be hazardous under the standard. So these resources are really helpful, and you should definitely consider these going forward. We have a question here about where can one find the hazard classification guidance for manufacturers, importers, and employers. You can find that on OSHA's website. Yeah, and we can send a link out to that guidance after the presentation for all of you that are interested in taking a look at that. Okay. The weight of evidence analysis, we'll touch on this briefly. The original HazCom standard used that single test rule, as we discussed a little bit, provided the threshold for chemicals to be considered hazardous based on just one single study. So one study that found that it was hazardous, that was sufficient. But since OSHA adopted the revised standard, the weight of evidence evaluation has become part of that process for determining whether the potential health and physical hazards of a chemical and what information is ultimately going to need to be disclosed on Sdss and labels. The draft guidance, as I mentioned, is on OSHA's website as well. The comment period closed on May 2nd. It's not final yet. It's much shorter than the other guidance. It's only about 30 pages, not 430. So it's much easier to read and review. But it provides specific details on what type of information to consider, how to evaluate the strength of evidence, the scope and use of the weight of evidence analysis, and some considerations in the use of that analysis. On the slide here, you have the steps of how to evaluate here. And first, you're going to want to obtain all the information that can pertain to a material and the possible classification. And second, the findings of the studies and other relevant information are then evaluated collectively to determine the degree of confidence that given toxicity outcome is causally associated with the substance. So this is, again, a qualitative assessment rather than quantitative. So there's no evaluation of the risk. We're just looking here at the inherent physical and health hazards. It's not going to be based on the amount of substance needed to trigger an adverse outcome or the level of risk to expose workers in the workplace. Risk can be addressed somewhere in the workplace-specific training. And And finally here, just I think is my last slide for the presentation, and then Kate is going to take over. This is related to byproducts. So the compliance directive indicates that byproducts are also covered by the HazCom standard, not just the immediate or inherent hazards presented by chemicals in its present form. Meaning a manufacturer's hazard classification needs to anticipate the full range of downstream uses of that product and account for any hazardous byproducts that may be formed. So you're going to need to think broadly here and anticipate how the product may be used and what other hazards may be created here. So an example on the slide here is a manufacturer of gasoline must inform downstream users of hazards of carbon monoxide known to be present as a byproduct from use of gasoline. So with that, I'll leave you, and we can answer some questions at the end. But Kate is going to take over for me and wrap up the presentation. Thanks.
Hi, everyone. All right, let me run through a number of issues that have been addressed by OSHA over the last couple of years, some of which were addressed pretty quickly after OSHA issued the 2012 standard, and some have been addressed more recently. All of these questions are questions, for the most part anyway, that have been asked by a lot of either employers, downstream employers who have responsibilities under the standard, or chemical manufacturers and importers. Tricky questions that are not answered by the regulatory text itself. First of all, immediate containers. I want to just remind everyone, OSHA's taken this position since shortly after they promulgated the standard. I think early 2013, they issued their first interpretation letter. Oh, sorry. OSHA issued their first interpretation letter about immediate containers. Where does the HazCom standard have to be located? It has to be located on the immediate container. And that's really important. A number of companies have attempted to convince OSHA that the containers are not suitable for this sort of labeling that's required under the HCS, but OSHA has taken a pretty hard line on this, and the law remains that, except with a few exceptions, which I'll talk about in a minute, the HCS label has to be on the immediate container, no matter, okay. Second, blank diamonds, and this has been OSHA's longstanding position since they promulgated the standard in 2012. No blank diamonds. You know that the pictogram has to be inside a red diamond-shaped border. Nothing can be, you cannot have one that has a blank. That would be confusing to the person who's reading the label, and so that's not allowed. You can't have the same pictogram appear twice on a label, and that's the case even if the hazard classification, if there are multiple hazard classifications associated with that pictogram, you can only have it appear once. That's also the case for mixtures where you have a number of chemicals that might have the same pictogram associated with the hazard. It appears once, notwithstanding the number of hazards associated with that particular symbol. Just a point here on enforcement discretion of the COSHOs as they enter chemical manufacturing facilities or even downstream employer facilities. The compliance directive that OSHA has issued has used the language should. So a compliance officer typically has a fair amount of discretion when they conduct an inspection to make a determination as to whether they ought to issue a citation or make a referral to issue a citation or not. Here, the compliance directive is pretty clear that the agency, that the COSHO should make a referral for a issuance of a citation if there's a violation of the Sdss requirements or the labeling requirements. And that's for downstream employers as well as chemical manufacturers. Next slide. Okay, I want to talk about, for those of you who manufacture products here in the U.S. but are manufacturing them for export only, there's been development, a pretty significant one, in this area over the last 6 months. OSHA has issued at least one interpretation letter, and I know there's a couple in the works that essentially do the same thing. So OSHA's policy now for export-only products is as follows. If you make a product in the U.S. for export only, and you are sending it to another country, a foreign country outside the U.S., whether it has a hazard communication-like program or not, you now are allowed to label with the destination country's label under the following conditions. If the product is one where you manufacture and it is sealed and immediately sent to the dock or the airport for transport overseas, and there's no stopping either at your own facility for storage purposes or another third-party manufacturing facility or warehouse, manufacturing facility or warehouse, you are allowed to put the destination country's label on. However, you have to, one, and this is pretty obvious, you have to make sure that the product is sealed upon its leaving your workplace. Then that's, of course, going to be the case. Two, you have to make sure that it is shipped in a shipping container that is DOT or otherwise approved. For instance, if it's ISO certified, that would be acceptable, but you have to have it in an appropriate shipping container that has been determined to be approved by whatever regulatory agency might be reviewing it, or some voluntary organization has issued it a certification for that purpose. Three, the HCS label, the new label, does have to be on that shipping container. So you don't have to put it on the immediate container, but you do have to have it on the outside shipping container. So you've still got to create it and you've still got to use it. If you don't put it, and you don't actually have to have it on the shipping container if you send it along with the bill of lading that goes along with the product. So let me just make clear. It goes on either the outside shipping container or with the bill of lading that accompanies the product. All right? The final requirement is the shipping container itself has to be compliant with any labeling requirements that otherwise apply, like, for instance, DOT or IMO requirements that would apply to that container. Those labels have to be on there. Now, query how OSHA has jurisdiction over that issue, but their enforcement discretion in not requiring a label to be on the immediate container is based on you complying with these other requirements. They're thresholds to this accommodation. Second situation is where you have a product that is manufactured for a destination country overseas, but it is stored at least temporarily on your work site. In order to not put the HCS label on the immediate container, you have to comply with all the previous 4 requirements that I've mentioned, and also you need to have the workplace label, the F6 workplace label, on that container while it's being stored at your facility. Third situation is where you manufacture for export only, but you not only store it at your own facility, or you perhaps don't store it at your own facility, but do store it at a third-party location, someplace that is remote from your own facility, like a warehousing situation. There, you have to comply with the previous requirements that I've mentioned. You also, basically what kicks in here is Section B4, the scope and application provision of the standard that, as had long been in place before 2012, which applies to sealed containers that aren't open during normal conditions of use or foreseeable emergencies. You have to comply with that provision for this scenario, and what that provision requires, of course, is that you have to have an Sdss accompany the product, and you have to do employee training for those workers who are at that remote location who would be potentially exposed to the chemical in the product. So those are a couple of additional requirements. If, though, you do all those things, you don't have to label your product with the HCS 2012 label. Next item, containers. This is just a recap. Just want to make sure everyone understands, containers include a lot under HazCom. It's not just what you would think of, but it's gas cylinders, for instance, palletized and bound bricks, for instance, any sort of similar packaging that contains a chemical would be covered by the HCS standard, and you would have to have the HCS label on it. Now, one thing that is accepted from it are piping system or operational systems that are in existence that may move chemicals through them. That is not covered by HCS. What about tank trucks or rail cars that contain chemicals that move over road? Those items, those containers are covered by HCS. And so you have to have a HCS label on that product, or you have to have it, that HCS label accompanying your shipping papers, your bill of lading. And I know we're getting some questions in, but because of time, let me go through what I want to share with you, and then circle back to your questions, if that's all right. Okay, other labeling issues that I want to make you aware of. Let's see, supplemental information. Okay, what can you add to the label in addition to the 6 elements that are required under the HCS standard? You're allowed to add supplemental information, okay? You can put what you want to include as long as you do not, by that information, confuse the reader of the label as to the intent and understanding that is provided by the required elements. All right, now what does that mean? OSHA has provided some guidance, some helpful guidance on what they mean by on this issue of inclusion of supplemental information. Let me just share with you what OSHA says. One, intertwining the supplemental information with the HCS 2012 information in a way which prevents the worker from easily identifying the required information is not allowed. So I recommend against any intertwining of supplemental and required information. If you want additional information, you manufacturers out there, put it in a different area than the required 6 elements. 2, displaying the supplemental information more prominently, say different font size, different color of the ink. That's likely not going to be allowed, and that label will be found to be non-compliant. 3, placing the supplemental information on the outside of, say, a foldback label. You know, so those of you who are making small packs labels, you're probably familiar with foldbacks. You can't put the supplemental information on the outside and put the HCS required on the inside. That would tend to hide the information that OSHA wants to make sure the downstream employee is receiving. So you can't do that. Providing elements in a foreign language more prominently, let's say, than the label elements that are in English that are required. Or providing the supplemental information in a manner that requires, let's see, required label elements in English that are not the most prominent item on the label. But bottom line is, the hazard communication required elements have to be the most prominent elements. You cannot use symbols other than those required in the pictograms in the red border. So if you have a red border, you cannot put an additional picture on the label inside that red border. Okay. Safety data sheets. Let's talk about what OSHA has said about what is required under safety data sheets that might not be obvious from the regulatory text. First of all, the individual SDSs required for any final chemical product. You need to have one for every chemical product, all right? You cannot rely on multiple SDSs for individual components and say together those provide an appropriate STS for a mixture or a compound. You have to have individual SDSs for each chemical compound or mixture in your facility. Second, I think Dan talked about this, swapping out old MSDSs with the new SDSs. I don't think Dan mentioned this. Note that under 1910-1020, the requirement to maintain employee exposure records, MSDSs and now SDSs are employee exposure records. Okay, so when you're in the process, or you have been in the process of swapping MSDSs out for SDSs, remember, you still have an obligation to maintain those those MSDSs as exposure records under 1910-1020C5(3). So don't throw those out. Maintain them as you would pursuant to that regulation. All right, SDSs must transmit with the first shipment of chemicals to each downstream location. You know that. One thing to keep in mind is transmitting, if you're a manufacturer or importer, transmitting to one facility of a multiple facility company is not good enough. The first shipment that goes to each and every facility that you send to has to have the new SDS with it. And similarly, you cannot transfer the new SDS to the to the downstream employer's headquarters and say, all right, I'm done. I've provided my SDS. You have to send it to every facility to which you are sending the chemical. All right, what about a situation where the chemical manufacturer has gone out of business? What is the employer's obligation? Do you have an obligation now that we're past the deadline to create your own SDS because you're not getting it because the manufacturer is no longer around? The answer is no. You don't have to, but if you do, remember it's kind of like, the botched rescue under tort law. You can't do it improperly. If you take on that responsibility, the obligations of the chemical manufacturer under the standard, which are much more onerous than to the downstream employer, kick in and apply to you. So if you're going to do that, you need to make sure you take it on and do it correctly. All right. I think we talked about this earlier. Your obligation as an employer, downstream employer, non-manufacturer, to replace your MSDSs for your existing chemicals in your stock, at your facility. You do not have a requirement to contact the manufacturer to obtain new SDSs for products that were received prior to 2012, for which you have an MSDS. Keep the MSDS, and then as you get new products in, you have the SDS associated with these new products. So you may end up, unless you do a full clearing and replace the old ones, which you're allowed to do, if you will have a facility where you've got old and new SDS, MSDSs combined to cover the gamut of chemicals that you have in your facility. One thing to keep in mind, you have to train on the old, as long as you have one MSDS in your facility, you need to train your employees when you do HCS training on that MSDS as well as the SDS. Okay, so they need to know, your employees need to know how to read those MSDSs and what that information that's on there means to them in case of an emergency, in case of an exposure. How do you keep these? The form in which you keep SDSs. This is probably something many of you already know. The standard does not specify how you must maintain these, what format they exist in. So they can be paper, like in the old days. They can be electronic, online, on your system. And they can be, there are these vendors that exist that, whose business is to maintain SDSs for a huge swath of chemicals. You can rely on those vendors, but some things to keep in mind. If you do anything other than even if you keep paper records of your SDSs, one, you can't keep those records, those SDSs, in a place where the employee has to go to you, their manager, their supervisor, and ask you for a copy, and you then get back to them with a copy. The employee has to have immediate access to those SDSs, okay? Now, that doesn't mean they have to be, posted everywhere where an employee can see it wherever they look, but they have to be able to go to it and get it readily. So that doesn't mean requesting and receiving a few days later. That means having an access, either a book, and they know when they're done, when the training is done, they know where that book is, and it could be in one location or maybe it's spread out in different locations. So where your chemicals are, the SDSs are nearby. You cannot require them to do a Google search and find the Sdss for methylene chloride. They are not, that is not their responsibility, it is your responsibility. Even if their jobs are, they're very proficient in using the computer in their job. Now, you can have, as I just said, an intranet system whereby the Sdss are kept electronically. But you have to make sure that, one, you've got computer terminals available to employees to get on. So, line workers, factory workers who don't have a terminal associated with them, they have to have something that's available to them to pretty readily be able to access that intranet site and grab that Sdss. You also have to make sure, and this is, this one is, some would say probably a little bit of a gotcha by OSHA, but I can guarantee you that over the next number of years, as this standard becomes the standard with which everyone in the country is complying fully, OSHA is going to be looking to make sure that there's backup procedures in place in case there's terminal outages. Listen, if you have an accident at your facility that impacts your computers, there's a possibility it could also be the same kind of accident that could trigger some sort of accidental exposure. And you do not want to be in a situation where you have an accidental exposure and the computer terminal that an employee needs to access immediately to find out what to do is also out. So think about that. And then, you have to be able to, in your training, make sure that those employees know how to readily access those Sdss. Okay. Combustible dust. Just a couple of words on combustible dust. We've talked a lot. I'm sure any of you who are responsible for in a manufacturing facility and or a downstream employer who have potential for combustible dust has probably done a fair amount of reading on this. But just as a reminder, as you know, HCS 2012 does not define combustible dust. It relies on the National Emphasis Program Compliance Directive definition of combustible dust that is right here on the screen, and you have these slides. Couple of points to remember. Manufacturers must provide information related to the hazard of anything that is essentially a foreseeable use, normal use or foreseeable emergency, right? So if there is a chemical where, if ground, it turns into a powder, and that powder is combustible and can generate combustible dust, the manufacturer has to warn of that hazard on that product label, even if, when it's transported, it is not a powder. That's really critically important to remember. The warning that is required, the hazard statement, you've got to say, may form combustible dust concentrations in air. OSHA has issued an interpretation letter on March 4th, 2014 on this issue, and also has issued if any of you are concerned about whether your chemicals could pose under normal conditions of use or a foreseeable emergency a combustible dust hazard, look at paragraph C31 of Appendix C to address this question. I'm sorry, I'm moving through this pretty quickly to keep us on time here. I think this is, again, I'm going to, for those of you who have potential combustible dust issues, note, and I'm sort of repeating myself, but even where the chemicals are not shipped in dust form, but the downstream user may do something to the product that would generate the dust, and that thing that the manufacturer might do, that process through which that product might be put, if it is foreseeable that dust that is combustible may form, you as the manufacturer need to warn of that hazard. Another point about combustible dust, you who generate the combustible dust, say for instance grain elevator operators, sawmills who are actually taking a product and generating that dust, you have become the manufacturer of that product, of that that byproduct or that product, and you therefore have the responsibility that manufacturers have under this standard. Okay. Temporary workers. Just a couple of words on how the hazard communication standard applies to multiple employer work sites and temporary workers. You may know that this administration, Dr. Michaels, is very focused on protecting temporary workers who are put in a workplace and who typically are not trained as well as or as thoroughly as the permanent workers that exist on site. And the agency has issued has developed a whole initiative associated with temporary workers. If any of you have temporary workers on site, please make sure you avail yourselves of the information on OSHA's website about temporary workers. But as it applies to HazCom, a couple of points that I want to raise with you. So let's say you're on a multiple employer work site, all right, and there are chemicals there. You as an employer have got to be responsible for making sure that you provide a method for other employers whose employees might be exposed to your chemicals to avail themselves of the Sdss, all right? So you have a responsibility to make sure that your Sdss for your chemicals that you bring onto a multi-employer work site are available to other employers who have employees at that site. It is not that other employee's responsibility to get the Sdss. Actually, they have that responsibility as well, but you, even though they're not your employees, have the responsibility to develop a method whereby those Sdss can be available to other employees. Also, you as an employer are responsible for providing updated training on the hazards associated with the chemicals you bring to a multi-employer work site. Those are hazards you are introducing even to your employees who are other than yours. That is, other subcontractors, employees. It is your responsibility to make sure their training is updated to cover your chemicals. Very important responsibility to be aware of. All right. I'm going to run through a couple of just, I think, sort of basic points about enforcement, and then maybe we'll have a couple of minutes here for questions. And by the way, as you all probably know, Eric, Dan, and I are happy to talk to you offline to provide additional information, links to various documents that we've referred to here. Before I talk about enforcement, I do want to just go back to weight of evidence. As Dan pointed out, OSHA issued this guidance that is a very important piece of writing that OSHA has done, and I think they've done a thorough and good job in attempting to put some definition around what they mean by weight of evidence that is a critical piece of your hazard classification. So make sure you read it. As he pointed out, it's not overwhelming. You guys who are frontline here making these hazard classification and categorizations need to understand what OSHA means by weight of evidence. Okay, so enforcement issues. As I think we mentioned probably every time we talk to you, hazard communication is one of the top 10 most cited standards for the agency. Our expectation is that this is only going to increase over the next couple of years. This is a critical few years for this standard. All the compliance deadlines have kicked in, but for these sort of deferrals, these lagging deferrals that OSHA is granting, but soon those will be behind us as well, and everyone's going to have to be in full compliance. Everyone, to reiterate, has to have, as of a few weeks from now, June 1st, 2016, a written hazard communication program. Even you downstream employers have to have a written program. Okay? So be aware that any inspector who's coming on site on their checklist to check is going to be to ask if you have your written program after June 1st. And it's not just the old program. It's got to show that it's been revised to deal with 2012 revision to the standard. A point about the general duty clause. This is an interesting point. As you know, OSHA doesn't issue that many 5A1 general duty clause citations, in part because they're harder to, the burden is higher on the agency for its prima facie case. One of the critical essential elements of OSHA's burden in a general duty clause case is that it has to demonstrate that there's a recognized hazard. And there's a lot of OSHRA case law about what that means. It's essentially there's three ways to show that the agency meets that burden. One, it can show that the employer actually has knowledge of that hazard. Two, it can show that it's common sense. Any reasonable person would recognize this particular situation or condition as hazardous. Or three, the industry in which you're operating is aware of this hazard. All right, those are three ways to show to meet that element of OSHA's case, the recognized hazard element. Well, how does HazCom relate to that? And this isn't necessarily associated with HazCom 2012. This has been the case always, but it's an important point to note that one way for the agency to show that this hazard at issue that they're citing someone for under the general duty clause for is recognized is to show that there's an Sdss for this hazard, and or perhaps rely on the labeling information that's on the chemical that shows what those hazards are, right? Because that's right there in your workplace. You should be aware of it. You have to train on it. Of course you're going to know about it. So OSHA can use the Sdss and prior to this the MSDS to support the recognized hazard element of a general duty clause citation. It can also use that same document, that same Sdss or formerly MSDS, to show that there's a feasible means to eliminate that hazard. And where do you look? You look at the categories of the 16 blocks on the Sdss that deal with how you eliminate or reduce the hazard. And that will tell you what you do to protect against that hazard. Well, that is a feasible means to abate that hazard, arguably, and therefore OSHA has met two of its four elements that are necessary elements to prove a general duty clause citation. Repeat citations, just a note on this. OSHA can use and will use former citations prior to 2012, prior to the revision to the standard, for HazCom to cite after 2012, now, and in the future, to cite an employer for violation of the hazard communication standard, even if it's a citation related to an MSDS an Sdss. You have to, under the standard for issuing a repeat violation, you have to demonstrate that the citation is for the same or a substantially similar condition or hazard. So if you had a prior HazCom standard violation and you have a new HazCom standard violation, arguably you can rely on that old one to cite the new one as a repeat violation. So be aware of that. There's not we don't start clean as of March 2012 on repeats for HazCom standards. And I think OSHA is going to be looking to bring, as one way to sort of help the regulated community be aware of the changes to the standard and help come into compliance. They're going to probably try to issue some pretty serious HazCom standard violations and make those very public. So everyone, it's another way to bring awareness to the regulated community, and something that Dr. Michaels is kind of famous for. So be aware of that. And this is just a slide that emphasizes how much, even though they're still a small number, how much OSHA has increased the use of the repeat citation over the last couple of years, over the last decade, essentially. It's essentially doubled the use of repeat citations, again, as an effort to make the community, to press them harder, to make them aware of whatever the citation at issue is, the underlying allegation, and to come into compliance with. So let's just see. We've got a couple of questions. So are we getting containers delivered to us that are not labeled with the GHS label? We need to make labels. Okay, we addressed that question already earlier in the seminar. So let me go on. So for secondary containers on site, not leaving location, we do not need full labeling. We can comply with 2012 identifying substance. Okay, so for this is the workplace labeling question. Yes, you can comply with workplace labeling if it doesn't leave the facility. However, a couple of things to note. One, the workplace labeling requirements have changed as well. And Dan gave you the deadline for compliance. That's this coming June, right? I mean, 3 weeks from now. So there's new requirements for workplace labels. Yes, you can use them. Yes, they might be considered easier than the, this full 6-element label that we've been talking so much about, but make sure you're aware of the new requirements. 2, leaving your facility. That's an interesting, esoteric question that you wouldn't maybe expect would be esoteric. Leaving your facility means leaving that facility, not leaving your company. So if you're transporting from one facility over public roads to another facility, even down the road, that is leaving your facility, and that is full compliance with the workplace, with not using workplace labels, but using the non-workplace, the regular labels. Okay, temporary containers. That standard is in the regulatory text, which I don't have in front of me, but I can tell you that I don't believe that the standard for temporary containers has changed. So look at F, the subsection F of the standard, the regulatory text. If you are using a container to transport inside your facility, chemical from one spot to another, like a bucket, for instance. And the key here is it has to be the same person. This temporary container does not have to have the label on it, but under the regulatory text, but it has to be in the control of one employee. It cannot be a situation where an employee puts a chemical into a bucket, sets it down, and then on some, rotation, or conveyor belt or something, some other employee comes and picks it up and disposes of it or uses it puts it in the next vat. That shows control by more than one employee, and then that is no longer the exemption for temporary container labeling no longer applies. Okay, let me see about this one. Do I need to train the employee if the Sdss of a substance changes? Even if the employee has training on the GHS, Pictogram, risk, all elements of the program. So I'm not sure I understand this question, but let me try to address it by saying that yes, you do need to, if the substance changes, then the Sdss is going to change, and yes, the training has to be updated to the new Sdss. So hopefully I'm answering your question. Feel free to reach out either immediately after this webinar or anytime you want to talk more about that. I may not be understanding the question correctly. So unfortunately, we're out of time. I'm seeing one more note in front of me that I forgot to mention. Before we close shop here, let me review one point on imports. I talked about the new interpretation of the HazCom standard for export-only products, but I didn't mention imports. One thing I want to point out is an importer has the duty under the HCS to label, to do all the things that the manufacturer has to do. It doesn't kick in until the importer takes control of that product. So if a foreign manufacturer is sending to an importer in the U.S., your responsibility as an importer kicks in the moment you take control of that product. The first employee exposure, one of your employees who is exposed to that product, it is your responsibility. But prior to that, when it's coming in, you obviously, as an importer, don't necessarily control the shipping container or the manner in which it is brought to your control, to your facility, and you don't have responsibility there. And so, that's for those importers out there, that's an important consideration. Do make sure, though, as not under OSHA but under DOT requirements, that manufacturer who's pulling that, exporting that product, and you as the importer need to comply with all DOT labeling requirements for that shipping container before it even arrives at your facility. All right. With that, let us close shop. Feel free to reach out. We love talking about HazCom, and we think that OSHA is doing, a very good job of issuing interpretations and guidance documents to provide a better understanding of what the 2012 regulatory text meant. We're poring over those interpretations and guidance, reaching out to the agency, having conversations with them. The agency's trying to be as helpful as it can be in figuring out what they meant when they wrote the standard. So feel free to call us. Thank you very much. On behalf of Eric Conn, Dan Deacon, and myself, we appreciate your time, and we look forward to talking again sometime soon. Thank you.